Yeah, I think, does Mark, given it's in Mark's constituency, just a quick...
As a Derbyshire account holder, but not with this particular product, obviously I've had people contact me about this as well, so I'd welcome an explanation of how people who invested in a Derbyshire offshore product ended up unwittingly, as far as one could tell, as account holders with an Icelandic bank.
Well, I think
because they weren't given an opportunity to say thank you, I'm not going to do that.
We have to be clear that was the Derbyshire chose to sell its business of Derbyshire offshore Isle of Man to Cowthing, and they then ended up in Cowthing Isle of Man, which it is important to realise was not a subsidiary of Cowthing, Singer and Friedlander. It was a direct subsidiary of Cowthing, Iceland. Now, I'm sure what the Derbyshire would say is that, at least in theory, that did not disadvantage those people because they were being transferred from one Isle of Man registered bank to another. Clearly, however, they ended up in a slightly different situation than they were before. But in legal terms, they did not. I mean, they would still have been an Isle of Man.
The depositors were given no opportunity to move their savings.
They would have had it at the end of the deposits, the term of the deposits. And let's remember that the transfer was done on the 20th of November 2007, so that those who had deposits which were maturing over the last year could certainly have chosen at the end of that deposit maturity to move their money elsewhere. So I would imagine that would actually be a very significant proportion of them. Now, I accept entirely that they may not have understood entirely the implications of what's going on. Now, they should have, because I have in front of me here the letter. The letter in no way implies that Cowthing Isle of Man is a UK bank. It in no way implies that it has a relationship with Cowthing, Singer and Friedlander. It doesn't in any way imply that it is regulated by the FSA, which it is not. But I think we can accept that it is a sorry situation.
Well, it certainly is, because they invested essentially through a British building society, and may have imagined wrongly that they would be protected by building society law.
Well, they invested in an offshore wing. Yeah, that is the complication.
The brand name may well have led them to think that the association was with a building society and covered by the protective envelope of the building society.
Can I say just a couple of things here? This is a case where, again, I think we need to look carefully at what we do. We've said time and time again, people ought to be aware of what it is they're investing in, and obviously in some of these banks that are not registered in this country, they use names that perhaps don't immediately alert you to the fact they may not just be yet another British bank. And certainly in relation to the Derbyshire experience, that's clearly something the FSA will want to look at, and that people, I think, have a reasonable expectation, and most people who put their money into building society tend not to be going through studying all the form and everything else. I think the second thing that concerns me is that we have a situation here where because Iceland is a member of the European Economic Area, the bank was passported into our system. It is not a satisfactory situation where you've got a branch here which actually had more deposits than it had back in Iceland, and yet we were not, we were not regulating it, and that's not a satisfactory situation.
Well, actually, we raised that in June, Chancellor, at that point, but we're going to come back to this issue. But Graham, a couple of minutes to finish.
Time's very short, so one question, but it may need a response both from Lord Turner and from the Chancellor. First of all, I'd like to know what role the FSA had in advising the Isle of Man Financial Supervision Commission to require the transfer of £550 million to the UK prior to the freezing of assets in the UK. And the other part of that question, doesn't this mean, the fact that transfer took place, doesn't it mean really there is an obligation on the United Kingdom government to return that £550 million to the administrators in the Isle of Man so that they can fulfil their obligations to the depositors there.
No, it's not the case that we required them to transfer.
No, I didn't say you required.
Oh, okay. I thought you did.
What contact did the FSA have with the FSC in the Isle of Man?
Let's be clear. The Isle of Man Kaupthing chose to place a deposit with Kaupthing, Singer and Friedlander UK. When Kaupthing, Singer and Friedlander UK, for reasons which we could talk separately, which was regulated by us, we decided it did not meet threshold conditions, that deposit with Kaupthing, Singer and Friedlander became a general creditor like other general creditors, and it will get paid out according to the dissolution of Kaupthing, Singer and Friedlander. The only relationship we have had with the Isle of Man authorities in this is that we have explained to them our general processes of how we regulate banks, including how we would regulate, for instance, Kaupthing, Singer and Friedlander. But we did not give them specific assurances to say this is a necessarily safe bank, because that would not be a reasonable thing for us to do. It is not for us to end up saying to somebody, we can give you an absolute assurance of this. We can describe our general processes of prudential regulation, but at the end of the day, it is for, in this case, the managers and the executive and directors of Kaupthing Isle of Man to make a decision about where they want to place that money, and in particular whether they want to put it in a very concentrated fashion, because I think that is a feature, that this was a relatively large deposit relative to the size of Kaupthing Isle of Man.
And Chancellor, do you accept the responsibility on the British government to return that £550 million to the Isle of Man? So
it doesn't belong to the British government. The deposits of the Kaupthing were transferred to ING, and the rest of Kaupthing's assets here will belong to the creditors, and I don't think that has to be dealt with through the due process. I would just add another thing, that I actually think, having looked at what's happened over the last few months, we really do need to have a long, hard look about the relationship between this country and the Isle of Man, a tax haven sitting in the Irish Sea, where we really where it's leading to perhaps people not being clear as to what the different rights and responsibilities are. But we can't have a situation where you have sitting there all sorts of tax advantages accruing to being in the Isle of Man, and when things go wrong, people then say, well, what about the British compensation scheme? So it is important that we take this opportunity, not rushing into it, not a knee-jerk reaction, but I think we do need to have a look at it, and indeed that's something your own committee might want to look at as well.
Chancellor, we actually have visited Isle of Man and Jersey on that, and we are going to be reporting on that. But in that graphic note, I think we'll bring it to a halt. Chancellor, the committee a few weeks ago visited Japan to look at their crisis and to see what lessons are to be learned. And one major lesson was that public support is important, but it may be difficult to gain because of the perception that we're just bailing out banks. And secondly, that conditionality applied to public intervention is important, and it helps to secure mainly public support. That was why you were here today to explain that situation. We're very grateful for the explanations you've given, but we're at the start of this inquiry, and we are going on to international regulation and other aspects, and we hope near the end to have you back again, because I think it's been a very worthwhile exercise, and we're grateful to all of you for taking time out of your very